Thank you more than I can say. Madam President, it's becoming habitual. Members of the governing boards and ladies and gentlemen. When I was younger, I used to hear Harvard stories from a member of the class in 1885. Back then, old graduates of the college who could get to Cambridge on commencement day didn't wait for reunion years to come back. They just turn up, see their old friends, look at the new crop, and drink some commencement punch under the elms. And the old man remembered one of those summer days when he was heading for the square after lunch, and he crossed paths with one of the newly graduated seniors who had had quite a few cups of commencement punch after lunch. And as the two men approached each other, the younger one thrust out his new diploma and he said, "Educated, by God." Well, even with an honorary Harvard doctorate in my hands now, I know enough not to shout that across the yard. But the university's generosity does make me bold enough to say that over the course of 19 years on the Supreme Court, I learned something about the Constitution of the United States and something about what judges do when they apply it in deciding constitutional cases. And I'm going to draw on that experience over the next few minutes because it is, of course, as a judge that I have been asked and given the honor to speak before you. The occasion for our coming together this afternoon aligns with the approach of two separate events in the judicial side of our national life. One is of course, the approaching end of the Supreme Court's term with the quickening pace of decisions that come down then. And the other is the approaching confirmation proceedings for a new member of the Supreme Court. And as a consequence of both of those impending events, we will be hearing and we will probably be discussing a good deal a certain sort of criticism that is frequently aimed at the more controversial Supreme Court decisions. We've all heard it, criticism that the court is making up law, that the court is announcing constitutional rules that cannot be found in the Constitution itself, and that the court is engaging in activism to extend civil liberties. I'm sure a good many of us here intuitively react that this sort of commentary tends to miss the mark, but we don't often pause to consider in any detail the conceptions of the Constitution and of constitutional judging that underlie that critical rhetoric, any more than we can stop to compare them with the notions that underlie our own intuitive reactions. And this afternoon, by way of a couple of stories and some lessons to be drawn from them, I'm going to try to make those comparisons with you. The charges of lawmaking, constitutional novelty, seem to be based on an impression of the Constitution and on a sort of template for deciding constitutional claims that go together something like this. A claim is made in court that the government is entitled to exercise a power or an individual is entitled to the benefit of some right, in each case set out in the terms of a particular provision of the Constitution. The claimant quotes the provision and provides evidence of facts that is said to prove the entitlement that is claimed. Once those facts have been determined, they, on their face, either do or do not support the claim. If they do, the court gives judgment for the party who asked for it, and if they don't, judgment goes to the party who contested the claim. On this view, deciding constitutional cases should be straightforward exercise of reading fairly and viewing facts objectively. And there are, of course, some constitutional cases that would be decided just about the way this, I'll call it the fair reading model, would have it. If one of this morning's 21-year-old college graduates, for example, claimed a place on the ballot for one of the open seats in the United States Senate this fall, the claim could be disposed of simply by showing the person's age, quoting the constitutional provision that a senator must be at least 30 years old, and interpreting that requirement to forbid access to the ballot to someone who could not qualify to serve if elected. No one would be apt to claim that lawmaking was going on, and no one would be likely to object that the age requirement did not say anything about ballot access. The fair reading model would describe pretty much what would happen, but cases like this do not usually come to court, certainly not to the Supreme Court of the United States. And the ones that do get there, for the cases that tend to raise the national blood pressure, the fair reading model has only a very tenuous connection to reality. We don't have to think long to show why it is so unrealistic. The Constitution is filled with deliberately open-ended guarantees like due process and equal protection and freedom from unreasonable searches, and these provisions cannot be applied like the requirement for 30-year-old senators. They require more elaborate reasoning to show why very general language applies in some specific cases but not in others. And over time, the various examples turn into rules that the Constitution does not itself specifically mention. But this explanation hardly scratches the surface. The reasons that constitutional judging is not a mere combination of fair reading and simple facts extend way beyond the recognition that constitutions have a lot of general language in them in order to be useful as constitutions. Another reason is that the Constitution contains values that may very well exist in tension with each other, not in harmony. And yet another reason is that the facts that determine whether a constitutional provision applies or not may be very different from facts like a person's age or the amount of the grocery bill. Constitutional facts may require judges to understand the meaning that facts bear before the judges can figure out what to do about them. And this can be tricky. To show you what I'm getting at, I've picked two examples of what can really happen. Two stories of two great cases. The two stories will not, of course, give anything like a complete description either of the Constitution or of judging, but I think they will show how unrealistic the fair reading model can be. The first story is about what the Constitution is like. It's going to show that the Constitution is no simple contract, not because it uses a certain amount of open-ended language that a constitutional draftsman would hope to avoid, but because its language grants and guarantees many good things, and good things that compete with each other, and can never all be realized all together, all the time. The story is about a case that many of us here remember. It was argued before the Supreme Court of the United States on June 26, 1971, and we all know it as the Pentagon Papers. The New York Times and the Washington Post had each obtained copies of classified documents that had been prepared and compiled by government officials responsible for conducting the Vietnam War. The newspapers intended to publish some of those documents, and the government sought a court order forbidding the publication. The issue had arisen in great haste, and it traveled from the trial courts to the Supreme Court not over the course of months, but in the course of days. The time was one of high passion, and the claim made by the United States was the most extreme claim known to the constitutional doctrines of freedom